country that I've seen it in their statute is Tanzania. And whenever it comes before the African court, we condemn them. We find them to be in violation of it. Then we talk about child marriage. Why can't we wait for the child to get education, to learn trade, so that in future, even if there is dissolution of marriage, the child can survive? Now the person is 14, 15. That is why I'm happy with the laws on the defilement. Because defilement, it is neutral, whether male or female, it is immaterial. Once you have sex with a person under 16 years, with or without consent, you commit it. But there is a gap between our law. So if you are of 16, that means the person is 16 and the person voluntarily have sex. That one, you cannot blame any of the parties. But the person cannot marry until the person attains 18. So at 16, you can have sex, but until 18, you cannot marry. What happens within that period, the gap? I believe in future we can fill that gap. If you cannot marry, don't have sex. So why can't we make it straightforward, 18 years? I think these are the things that we need to address. Thank you.
Thank you very much, my Lord. We passed the affirmative action bill last year, July, and since you have been a trainer, or you have been in the institution of the judiciary institution, I want to tease out your view on how you can, what do you think we should do to ensure gender parity in the judiciary? Thank you.
Thank you, Honorable Chair. The Judicial Training Institute has capacity to train the judges. But when it comes to the training, at times we are confronted with facility cash. That is the problem that we need. Because if you ask one judge to move from Kumasi to Accra for training, the person will come with the driver. The person will come with bodyguard. How do you accommodate them? It is the cost of the judiciary. But at times, the judiciary hasn't got enough budget to undertake these things. That is why at times you see donors coming in to help. But some of the donors to their donation, to me personally, when I was the director judicial training, I rejected some of them. They will go to the CJ. Because why should you come and tell me to train judges on a law that exists in your country and it doesn't exist in my country? I will not train. So these are the important things. So if judiciary submit budget and the training component, I will plead with budget. I will plead with Parliament that the training budget always preserve it for us, so that we can get enough money to train judges, to build capacity, so that they will be up to the task. Thank you.
Honourable Chair, let me take my Lord into the current trending global issues. Looking at climate litigation, such as, and let's look at the issue of Etiwa Forest, as the case has been limited in Ghana due to the lack of specific legislation. Would you support a right-based approach to environmental cases? And how would you balance economic interest with constitutional protection? Thank you.
Thank you. When we look at our constitution, there are two provisions which talk about protection of the environment. We will find it in Article 36, then we also find it in Article 41. That is the rights and duties of every citizen. And every citizen is required to help to protect the environment. It is a constitutional duty. Despite the fact that it falls within the directive principles of state policy, it is a positive action directing every person, every Ghanaian, every person in Ghana to help protect the environment. How do we protect the environment? There are enough laws, even though we complain that there are not laws. There are enough laws. What are they? Those in the Atiwa forest. What is the rationale? Who has asked them to go there? Do they have license to go and mine? They are illegal miners, and we have strong laws that will deal with them ruthlessly. So we have enough laws, but what to me is remaining is about enforcement. We must enforce it. Those in the Atiwa forest, they cannot fight the entire Ghana army. They cannot fight the entire Ghana police. Why can't they arrest them? If they arrest them and they bring them to court, they are dealt with and they are sentenced to a number of years as prescribed. Here we are talking about deterrent and preventive. We achieve some of the theories in criminal law. So Honorable Chair, what I will say is that yes, we need to fight it, and it is corrective effort, because the law does not say that only police should fight. It says that every person shall contribute to the protection of environment in Ghana. Thank you.
My last question, Honorable Chair. What 3 specific constitutional amendments would you recommend to modernize Ghana's succession framework? And if I may ask, for each of them, if you can explain the current problem and your proposed solution. Thank you very much.
Thank you, Honorable Chair. Honorable Chair, my first proposal will be the district assembly. That the position now, we are saying that it should be non-partisan, but on the ground it is partisan. Why can't we be bold to say that this is what initially we intended to achieve, but it cannot be achieved, and therefore you can go partisan way, because that may help, because as it is now, we are saying that it should be non-partisan, but every assembly member, they will tell you that this one belongs to this party, this one belongs to this party. So that is my first one. And the second one concerns my own work as a judge. Judges sitting in court as additional judges. That one should be abolished. Judges sitting in court as additional, because it is not done in any country. It is not done in any country. We have enough high court judges. Why is it that if there is a case to be tried by a high court judge, we ask a court of appeal judge to go and sit? We have enough circuit court judges. Why is it that if there is a case before the circuit, we ask a high court judge to go and sit as additional? You know, that one we are talking about human influence, and we must reduce it, we must curb it. I have examined almost all the constitutions in Africa, and I haven't seen in any country where they ask judges to go and sit in another court as additional. So if we do away with that one, because always when a judge from a higher court goes down to sit on a matter, the impression is that why can't we get a judge from that court, but we bring a judge from another court? So even the mindset alone, it speaks volume. They start talking about bias, whereas we have enough judges for the same court. So to me, that one should be abolished. It is my own opinion, because of the constitutional analysis that I've made. I think it should be abolished. So having said about these two, I think it is enough. Thank you.
Thank you very much. I wish you the best of luck. Thank you.
Thank you. I'll proceed to give the floor to Honorable George Kweku Ricket Hagan, the Vice Chairman of the committee.
Thank you very much. Sir Dennis or Lord Dennis, I'm sure each of them will go. Congratulations. My question will be an expansion of the question that Mr. Speaker, and that is second Deputy Speaker, asked. And he was looking at whether there should be some additional courts to deal, constitutional courts to deal with issues. But I want to look at the entire court system or the entire judicial system. There are a lot of complaints that there are a lot of cases building up in our courts, and that some of the reasons is that we don't have the manpower to do the work, or there are some inefficiencies that need to be worked on. There's another school of thought that thinks that we should automate our courts fully, or at least to a greater extent. And that is to bring in that the functions of the court were mainly based on some kind of a database systems and management to be able to move things much quicker, in the court. We do say that the wheels of justice grind slowly, but it looks as if things are grinding much more slower than they should. In your view, would you also share that view that we need to automate our courts or computerize our court systems to become efficient enough to move cases much faster than they are being channeled at the moment? Thank you.
Thank you, Chair. The court has passed through several stages to ensure airy disposal of cases. We started with the scopists, that they will move fast. Then at a point in time, we saw that the scopist work was not also moving. So we moved to the next level. The next level was to promote automation. Automation, at times, staff will be working and the light will go off. The court becomes standstill. Now, the aim of the judiciary is to achieve the e-justice. And the e-justice, you cannot achieve the e-justice where you do not have dependable internet. Because number one, e-justice, we start with e-portal. Go to the website, you'll find everything that you need. Then after e-portal, then you move on to the second one, e-forms. When you need the forms, you just go and print. Then e-filing, you use the same form to file. Then after e-filing, e-case distribution. There will be no manual for the head of the institution to say that you judge, go and sit on this one, you judge, go and sit on this one. It should be automatic distribution. But we do not have all these things. Then after that one, then we move on to e-evidence. We take evidence, then we do electronic hearing. Then we move on to electronic judgment. We've been talking about e-justice, the e-8. As at now, to me, I don't think we have even achieved 2. So we need money to overhaul the digital system of the judiciary to enable us to use the equipment to dispose of cases expeditiously. Otherwise, manual, if you go to some places, you see handwriting. It takes some time. Then at times, apart from the handwriting, you get interpreters. All these contribute. So I think that it is the wish of every judge that the court will be fully equipped with the E8. When we have, it becomes even a joy for you to work under such circumstances. Because if you come to the African court, for instance, and we are working very, very fast, the number of decisions, even though apart from the president, the 10 judges are part-time. If I tell you that 1 year, we can deliver about 36 judgments within 4 months. So it is the wish. And I will still plead that Parliament, when we present our budget, please defend for us, don't cut, so that we can help to promote expeditious disposal of cases. Thank you.
Any further question?
Yes, Mr. Chairman, one more question, and this one is actually on a lighter note. I'm a bit curious about this. You realize that most of our courts, the ones that I've seen and ones that others have been, again, you did talk about energy, of course, power issue. But we tend to have, a lot of our courts don't actually have air conditioning or AC and these things. Where we have them, they don't work. But then we continue to wear our gowns and our wigs. So I'm wondering, I know it's a colonial legacy that the institutions like the judiciary got seriously. But you realize that the speaker has taken off his coat, and so are the other, the first and second speakers, and including the clerks. Don't you think the gowns, though they are legacies that maybe we treasure, it's a bit outmoded, that we should maybe start putting on our traditional stuff like the speaker and others are doing? You know, these things will be much more practical, or these clothing will be much more practical for our kind of climate than the colonial gowns that we continue to put on, and probably use them on ceremonial basis like we do in Parliament today. Thank you.
Thank you, Honorable Chair. Honorable Chair, the wig and the gowns, they have several significance. They have several significance. Now, was it 2012, 2013, 2014, there was a proposal that we should not be wearing wigs and others. And we found, in addition to what I'm going to say, we found that some people who were not lawyers were posing as lawyers. Because it's just a matter of getting this and that. You can go to any court, announce yourself, and then it's a day appearing for this one. But if you talk about Parliament, Parliament is just one. Speaker is just one. So I'm happy that Parliament has taken the bold decision. But for the judiciary, wherever you go, every court has its own robe. All the international courts, all the national courts. So to me, my policy is that, after all, it doesn't take away anything from us. It doesn't take away anything from us. What it does is that it sets you apart, that this is a judge. Look at, with its wig and gown. So to me, I treasure it. So, Honorable, I will not support your position. Thank you.
Thank you very much. I think that we need to repair the air conditioning.
Honourable members, lawyers who are wearing the wig and gown are not complaining, but non-lawyers are complaining. Is it because they have no opportunity of wearing them? Yes, it's now the turn of Osahin, Togbi Osahin Alexander Kwamina Afenyo Markins, the ranking member of the committee. You have the floor.
Lord, in 2023, did you do part-time teaching alongside your judicial duties?
Yes, please. Whenever I'm in Ghana, the law school, I teach. I teach. Initially, I used to teach the entire part too.
My Lord, I would crave your indulgence to give me direct answers. So I repeat, my Lord, in 2023, did you do part-time teaching in Ghana?
Yes, please.
In 2024, did you do part-time teaching in Ghana?
Yes, please.
Please, in 2023, the part-time teaching you engage in, were you remunerated?
Yes, please. But if I tell you some of them, you will laugh.
Oh, don't worry.
Yes.
What about 2024?
Yes, please.
Now, I have with me a GRA tax clearance certificate. You brought to us. Your TIN number GHA 711947735/0. It bears the name Dennis Dominic Ej. And the purpose, it says year of assessment 2025, and purpose to support my nomination to the position of Justice of the Supreme Court. I would like to know from you, by the way, do you have a copy of that tax clearance certificate with you?
I can have it on my, I may have this, sir.
May the clerks supply the nominee with a hard copy of what he has furnished the committee, please. My Lord, please, are you in possession of a copy of your...
Yes, please, I am.
Very well. Now, in obtaining this tax clearance certificate, I want to know from you whether you did the computation of your tax obligations yourself, or that you relied on the finance department of the Judicial Service for them to forward your details to GRA for the purpose of obtaining this.
Thank you. I forward to the finance division of the Judicial Service, and they know all the schools that I teach. So they take all of them into account, and they tell me that whenever it is paid, they take the how do you even call it, the VAT and others from it. So this one was obtained this year, but every year I do that. Thank you.
My Lord, you went ahead to answer a question I've not asked. So that's why I said, please bear with me and let's be on the same page, point by point, so that there will be clarity, you know. So you forwarded your details to them, the finance department of the Judicial Service.
Yes, please.
So regarding whatever computation they did with GRA, you were not privy to it.
After it is prepared, they bring it to me for my signature, and I sign.
Now, when they brought the document to you for you to sign, did you really pay attention to the details they had computed, or you assume that as professionals they've done the needful?
I presumed that the writing has been done.
All right, my Lord, that being the case, I will want to strongly suggest to you to get back to them so that they add your other remuneration from my checks. What they sent was your salary, what you directly earn from the Judicial Service. So, in other words, the tax certificate we have here does not constitute a full disclosure of your tax obligation. So I'll give you the opportunity to get back to them and urge them to do the full disclosure as you provided them. Is that okay by you?
Yes, Honorable, it's okay.
All right. So, my Lord, you agree with me that the presumption of regularity on their part really could have cost you some challenge here because they have not fully disclosed, and you also have the certificate bearing your name, correct?
Honorable, thank you. Honorable, I tell them to prepare, and for my house, the rent, I pay the rent tax myself, and that one, they disaggregate from this one. That is why I did not cross-check whether it has appeared on that one, so thank you.
Yeah, but you don't have a separate tax certificate regarding your rent tax or whatever you're talking about. I'm talking about your earnings. So you may go back to them if you want to assure this committee that you will do that needful. The records would permit you, and with the leave of the chair, so that we don't drag this.
Thank you, Honorable. I can do it. Even tomorrow, I can go there.
Yeah, what I'm saying is that you have to, procedurally, I don't have the powers. The chair must grant you the leave. So then I would not pursue this with assurance given with the leave of the chair.
Honourable members, the witness or the nominee is telling us that he's been paying the rent component of the earning directly. And normally, the GRA will consider matters as a whole in issuing the tax clearance certificate. So if you have any specific reason to doubt the tax clearance certificate that is here, you may say so. Then I can then use my discretion to decide whether to grant leave or not to grant leave.
Honorable, if leave is granted, I will be happy so that I will get it if there's the need for me to incorporate that one.
Very well. Leave is hereby granted.
Honorable nominee, let's do some little exercise on your CV. Page 8 of your CV. On page 8 of your CV, you have honorary position. And you state, quote, knighted by His Holiness Pope Benedict to the Order of St. Gregory the Great on the 18th of October 2005. I presume that it is this honorary position that your title, Sir Kamet, correct?
That is so. It goes with title.
Very well. So, this Order of St. Gregory, is it a fraternal society within the Catholic Church?
No, priest. It depends on the services that you have rendered. They look at 3 things: your contribution to your country, your contribution to humanity, and your contribution to the church. Then they make recommendation to Rome for Pope to consider. So if the Pope deems it fit, then the Pope may knight you into any of the categories. Thank you.
When you say any of the categories, what exactly do you mean?
We have the Equestrian Order. We have St. Gregory the Great. We have St. Sylvester. We have multiples of them.
But in Ghana here, your journey in Christianity within the Catholic Church, do you belong to any of the fraternal orders in the Catholic Church of Ghana?
That is so. I'm a member of Knights of St. John International.
Now, you would agree with me that a person who is a Catholic and not a member of that lodge is not admitted into its assembly and its practices. You'd agree with me?
Honorable, thank you. Catholic Church, we don't have lodges. We have the Knights. I done Knights of
the
Marshall.
fraternal order, correct? It's a fraternity.
It is a Catholic fraternal
That's
order.
what I'm saying.
Yes, please.
I'm not saying anything outside of it. We are in the Catholic Church. I'm not talking about anything outside of the Catholic Church. So,
Honorable
I'm
ranking
talking
member,
about a CV.
just calm down. The witness is telling you in the Catholic Church they don't have a lodge, they have a night. So please take the answer.
Chairman, honorable nominee, you would agree with me that those who do not belong to that fraternal society in the Catholic Church and do not know your practices and your value system often criticize what they don't know. You agree with me on that?
That is so.
And for your lifetime, would you confirm to this committee that you've come across such criticisms of such nature? You would agree with me?
That is so. At a point in time, somebody died. We went to bury him. We went to bury the person. They thought we were coming to resurrect the body. I saw them lying. So I invited all of them to come, because at that time, I was the Grand President. So I said they should allow them to come and observe. We are there just to pray for the disease. That is all.
Honorable nominee, if you say you are praying for the disease, but the priest, I believe that the priest had already prayed and performed those burial rites. So your fraternal group would also do further praying?
That is so. We don't have limit to prayers. Now, if I get even 1 million people praying for me, I'll be happy. So that is why even our deceased brothers and sisters, we continue to pray for them. And we have a day that we remember them. We call it memorial service, to remember and pray for them.
Honorable nominee, let's go back to page 2 of your CV, please. Please clarify for me. What certificate do you have for your first degree?
Bachelor of Arts, Law and Linguistics.
Would I be wrong to say that it has that Law and Linguistics, Bachelor of Arts, Law and Linguistics, has the same value as LLB? Would I be wrong to say that?
They had equal admission to the law school. So I would.
Now, clarify for me again. You have stated qualifying certificate in law, and you indicate 1991 to 1993. If my math is correct, that's 2 years, correct?
That is so.
For what I know, this Makola Ghana School of Law, the professional law, is 2 years, part 1 and part 2. Is that what you are describing here?
That is so.
So do I take it that having attained BA, Law and Linguistics, you were given an exemption not to pursue any LLB or do what they call the qualifying certificates in law prior to doing the professional? Because just by way of background, when you don't do LLB and you do BA, you would have to get in to do a post law degree program before you do the professional. I want the clarification. I don't know whether during your time the situation was different?
Honorable, during my time, the situation was different. Number 1 to 60, LLB and BA, all of you will go to the law school. There wasn't any distinction that because this one has done this, you need to do this. And it was 2 years.
No, I want some clarification again, please. Help me. So, your time, we had mainstream LLB students at the faculty, right? Who pursued the LLB. And from what you are saying, those of you who did BA, law and any other discipline, linguistics, psychology, etc. If you say 1 to 60, what exactly do you mean?
When you go to the first year, the entrance, the exam that we did at the end of the year, they will take 90 students during my time. They will take 90 students. Then the first 1 to 40, they will do LLB. 41 to 60 will do BL. All of them will go to the law school. 61 to 90, they ask them to do the 2 other subjects that they did.
Okay, so in other words, those of you who did B, though not strict LLB, were added to still pursue the professional law.
Yes, it was a matter of course.
Okay, very well. Now, Honorable Nominee, if you eventually get confirmed, how many years are you going to be on the bench to retire?
Close to 9 years.
In other jurisdictions, specifically the American Federal Supreme Court, there is no such retirement until death or resignation. There is this call for us to amend our constitution to extend the retirement age of Supreme Court judges. What is your own view on that?
Thank you, Honorable Chair. Honorable Chair, the U.S. system is a bit different. When you are of 65, you can take a senior judge status. So in that sense, you may decide to sit either 1/3 or half of your volume of work. They have senior judge status. And if you become 80 and 90, the number of cases that you will sit on, you decide, and it is given to you. That it is for the whole federal court, from the district court, circuit court, and the Supreme Court. You know, they call their high court district court. So district court, circuit court, and the Supreme Court. They call it appointment for life. But Honorable Chair, just 2009, the UK, they have increased the retirement age of their Supreme Court judges to 75. But for me, I think in Ghana, the 70 is okay. Because people go home within 2 years, they die. Because of the volume of work that we do. Thank you.
My Lord Ajay, you have made a very profound statement this afternoon in response to a question regarding judicial precedents, judicial decisions. And you made reference to this end-all concept where, according to your explanation, because of the judicial position taken by the presiding judge in a particular matter, the all was defined in a certain man. And later when he retired and the end group also took over, that one was stated to be the old law, and the new one was to take precedence. I agree with that. That's the general position of the law. Now, until 6th of May or so, the general belief was that when an injunction application is filed, once a party in that litigation is served, it operates as a stay until the matter is dispensed with. But my Lord Kulendi, in the recent 3-2 decision in the matter of Kowasifwa, has put that matter to a peaceful rest, to the effect that there must be an express order from the court. And it is that express order that can restrain a constitutional body or statutory body from acting in a certain way. Would you be of this new school of thought, or you remain with the old position of the law? I want to know. You are an academic. Let me hear from you.
Thank you, Honorable Chair. Honorable Chair, there are two positions at common law. At common law, one of the schools will hold that if the application is filed and it has not been granted, it does not constitute injunction and contempt cannot be founded on it. Then the second school is saying that if an application is filed against an act to be done and it is filed timeously, then the person must hold on and wait for the outcome. So there are two positions. So if Supreme Court has taken one of them, then that has become the position in Ghana, because there were two unsettled positions.
So now, express injunction is a rule. Mere filing and service is not, because, my Lord, I said this because in the Ablekuma North case, the Honorable Minister of Interior, when he was invited to appear before Parliament to explain why the security had failed to provide assistance to EC to enable them to complete, his answer was to the effect that the security services, fortified by the court's pronouncement, to the effect that once they have been served, they have to hold on. So he justified the point that because a party in that EC collation process had filed a process in court, they felt injuncted because they said they've been served. So EC itself was injuncted, although there was no express injunction, just the service of the process. So I would want to find out from you, you are going to the bench, how do you reconcile? Because these are two issues, and they all have national significance.
Honorable Minority Leader, with all due respect, the nominee is seeking for your approval in order to go to the Supreme Court. He is not yet a Supreme Court judge. We cannot get him to constitute himself into a Supreme Court judge to be commenting on these matters. Two, by your narration, you indicated clearly that the matter is before the court, and somebody feels that I have been injuncted by the mere filing of the injunction application. Who knows that if you give him the nod, he may be one of the judges who will have to sit on a contempt issue. So So getting him to make comment at this particular level, I feel strongly is outside the scope of questions that we should be asking the nominee. So I humbly plead that we move from that line of questioning to any other area.
My Lord, I've heard my chair. I want to give my chairman the benefit of doubt that maybe I didn't situate my question properly for him to appreciate it. But the whole exercise here is to hear your views on matters of law and national importance, public policy matters. And we are not asking you to make a judicial pronouncement. That is the point here. So I don't get it, but I would frame it differently. My Lord, the Ablekuma North Declaration, according to the records of Parliament coming from the Minister of Interior, the Ghana Police Service is unable to provide security because of the presumption that a party has filed a process at the Supreme Court. And to the extent that that process has been served on EC, the security services have been advised that it operates as a stay. Hence, they are not providing security until the matter has been determined. My question to you is that what is your own view on this presumption in the light of the Asefua case, where the majority of the court, speaking through the respected Justice Joni Kulendi, stated that it must only be an express court injunction to create that estoppel, rather than relying on a mere filing of the process.
Thank you, Honorable. Honorable, you have even stated that Supreme Court has decided, and once Supreme Court has decided, whom am I, an ant, to say that Supreme Court has said this, it should be this. So once there's a definitive pronouncement by the Supreme Court, then it is binding on all of us until it is varied. Thank you, Honorable.
Thank you, Mr. Chair. Mr. Chair, what I want to know from nominee is that as a jurist himself, and fortunately, you are of the academia stock on top of your work. I'm not talking about the estoppel imposed as a result of the judicial pronouncement. Here, we are discussing opinions and views. Okay? You are not sitting as a Supreme Court judge. In fact, even if you go, if you are confirmed and you are there, you are presiding on a matter, you would have the opportunity to express a view, whether you agree or disagree with that position of the law. You may be in minority or still join the majority. What I want to know from you is that the idea, the filing and serving on a party, do you hold the view that it should operate as a stay in the absence of an express judicial order?
Honorable Minority Leader, with all due respect, the nominee has stated clearly that once the Supreme Court has made pronouncement on the matter, who is he? Significant of the fact that he doesn't want to comment on matters that the Supreme Court has made pronouncement on. So let's make progress. I beg you.
Chairman, with respect, we've had a beautiful day. I expect you and I to appreciate the angles we take on the matters. I have understood him. He says he doesn't want to go there, and I have understood him. I agree. Now, I put the question differently, that at this point, I am soliciting his view on a matter. I'm not saying that he should go and criticize his colleagues who are there. I'm not saying that. Neither am I saying that he should sit here and overturn a judgment. I disagreed with the position of the majority. But in my recent review application on the House floor, I quoted it copiously because I'm bound. That is the law. And that is what I use in my review application to challenge your earlier ruling sustaining the preliminary legal objection of Honorable Ayerga against my motion on sub judice. I quoted, I relied. The cameras were there. The records of Parliament will bear me out. I am bound, and I agree with you. But it is not that path we are taking. I am asking that as a judge, as someone who teaches the law, what is your view on these schools of thought? Do you believe that there could be some exceptional circumstances where service of the process must operate as a stay and not to wait for express judicial order to restrain the person? I just want to know your view, but not to attack
With all due respect, the nominee was clear in the answer provided that once the Supreme Court has made pronouncement, the word he uses, who am I? So the Supreme Court has stated clearly what is his opinion as compared to the judgment delivered by the Supreme Court. Let us be very careful so that we don't constitute the nominee's vetting to sit as a court to either review the decision of the Supreme Court or comment otherwise on the decision of the Supreme Court. That is where we have to be very careful. That is what I am drawing your attention to.
Mr. Chairman, the whom am I phrase he used was in respect of he having the power to overturn that. We are not in that space. That is not where I am. The subsequent question that I framed was in respect of an opinion, in respect of the two schools of thought on this subject matter, not for him to attack the judgment. And I agree perfectly. That's not where I'm going. The gravamen of my question is, where do you stand in the two schools of thought? If I have to clarify, where do you stand in the two schools of thought?
Honorable, depending on the nature of the case, then that will influence my opinion. For example, if Parliament is sitting and somebody is bringing an injunction against Parliament from discharging its constitutional mandate, I will not say that the fact that it has been served, it constitutes an injunction and Parliament shall not sit. We are coming to have national elections. Then you rush to EC, serve EC, don't conduct presidential election. Then EC says, I'm not going to conduct by the service of the application. That's when it will create anarchy. So even the two schools of thought, we need to treat it case by case basis. Thank you.
My Lord, may we, I'm happy with this. It's a matter of case by case. It's not a rigid thing where you say there's an absolute position and all. And I'm satisfied. Thank you. My Lord, may we do a little exercise on Article 1442? My Lord, does my Lord have his constitution by him?
I've been given one.
And you have the 1442. You are there with my Lord. If you may read that aloud for us.
The other Supreme Court justices shall be appointed by the President acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. Thank you.
Okay. My Lord, I'm going to give you two practical examples, and I would put my question for you to express a view. So I claim your attention. First, I shall refer you to a letter dated 30th of May 2024, written by Her Ladyship, the Honorable Chief Justice Araba Isaba Tokonu, and the letter is addressed to His Excellency Nana Addo Dankwa Akufo-Addo, former President, Jubilee House. Proposal for appointment of 5 judges to the Supreme Court. Quote, I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana, and a list of 5 are there. Then it goes on to say, well, I don't want to go down there. The operative phrase that I would want you to pay attention to is, I write to respectfully request that the following judges be appointed to the Supreme Court. I repeat, I write to respectfully request that the following judges be appointed to Supreme Court of Ghana. Now, this letter from the Honorable, I have 2. You want it? Oh, okay. I thought it would be a waste of time, but Chair direct that I read the document as a whole, which I will do, don't worry. So I would now go over. I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana. 1. Her Ladyship Justice Angelina Mensah Homia, J. His Lordship Justice Eric Chebafo, J. His Lordship Justice Edward Amwakwa Santi, J. Her Ladyship Justice Sarah Pamela C. Ekranti, J. Her Ladyship Justice Ifia Sewa Ifia Asaribotwe, J. Then goes on. Justice Asante's term of office at the ECOWAS Court ended on the 31st July 2022. He was requested to remain at post on account of the withdrawal of Mali, Guinea, and Burkina Faso from the community. His current tenure is expected to end in 2026 or earlier, where he is expected to return to Ghana's judiciary. Now, this letter was publicly construed to mean that the Chief Justice was interfering with the powers of the President as contained in the Constitution, and received a lot of criticism. 1. 2, the general practice that we've known when it comes to nominations to the Supreme Court has been that nominations come from various stakeholders in the legal fraternity, and on the basis of that, the Judicial Council does deliberations on these nominations and makes a recommendation to the President for the final decision of appointment. Now, in the recent appointment of 7, of which you are included, there was a single letter that emanated from the Presidency directly to the Judicial Council, which letter directly effected the appointment and urged upon the Judicial Council to advise. My Lord, with these 2 scenarios given you, I want to ask you, within the context of the provision in 1442, which you've already read, and at the risk of being repetitive, I would go over, that other Supreme Court justices shall be appointed by the President, acting on the advice of Judicial Council, in consultation with the Council of State, and with the approval of Parliament. How do you place on the advice of the Judicial Council? Is it the case that they will nominate for final appointment as was contained in the decision of the Supreme Court in the matter of Ghana Bar Association against the Attorney General, when my Lord Mafusao, my Lord Apau, and my Lord Puaman were eventually appointed out of the 4 recommendations made to the presidency in a certain order. And the Ghana Bar Association took issue with the presidency that, look, Judicial Council made a certain recommendation in an order of merit. And it was Mensa Bonsu, Mafusao, Apau, and Puaman. But the president took from the bottom 2. How do you reconcile all these scenarios within the context of, upon the advice of the Judicial Council? What is the function of the Judicial Council in this whole process, in your view?
So
thank you.
My Lord, from all that you have said, what really is the question? The functions of the Judicial Council in appointment of judges, is that it? No, Minority Leader. Is that the question? Yes. Very well. Proceed to answer.
Honorable Chair, I know about the case because at that time I was the president for Association of Magistrates and Judges of Ghana, so I know much about that case. What happened in that case is that the president brought 7 names to be considered. Then Judicial Council added 2 names. Then the bar brought 2 names, and the Judicial Council conducted interview, and at the end of the day, they concluded that their nominees had been number 1 and number 2, and the one brought by the president 3 and 4, and the others have failed. Then the president said, once he has gotten Justice Apel and Puaman out of them, he will swear them because he has not nominated them. The law says he should nominate. So Nena Megache, then Nena Megache, now Justice Nena Megache, Justice Amenuvo, and Mr. Frank Beecham, they brought an action against the Attorney General. And the Supreme Court, the majority decision by Justice Atuguba.
My Lord was part of the case. It wasn't majority, it was unanimous.
Unanimous. Yes. What Justice Atuguba said was that, leading the lead opinion of the court, what he said was that every nomination must be endorsed by the president or must stem from the president. So this one, once it was not made by the president, it does not bind the president. That was the Supreme Court decision, which binds everybody. Thank you.
My Lord, I do not want to have a disagreement with you on this, but maybe sometime we may have to refresh our memory. I was involved in that case because our case was consolidated, because at the time I was counsel for a plaintiff who was challenging the appointment to the EC. So we had a consolidated case. I respectfully, and I do so in all modesty, the government of that decision was to the effect that, to the extent that the Judicial Council had made a recommendation of all 4 to the president.
Honorable Minority Leader, sorry to interject. The rules are clear. When questions and asks and answer provided, you do not argue, you don't offer an opinion, and you don't address. So please, ask another question.
Chairman, let's make this exercise as interesting as possible. Let us help shape the public discourse in a very coherent manner. All that you said is not what I am doing. My Lord has stated a view on a judgment that as a lawyer I really was part of. If I am seeking to clarify, I've not gone out of the rules. Please, you must also, please, respectfully, pay attention to my line of discourse so that you don't hurriedly rule me out of order or say I am saying something different. I am making
ask your clarification.
Sure,
question.
That's exactly what I'm doing.
Yes, ask clarification question.
Honorable Bid, please. Bid, you've had your time. Bid, please, don't do that.
You are entitled to ask a question for.
Chair is directing affairs. Please stay.
Honourable members.
Stop.
You are entitled to ask a question to clarify.
You don't have
But
a better personal relationship with my Lord than I. Stop it.
The comment.
He knows me.
The
Please,
argument.
stop
The sharing of opinion is what the rule says we cannot do regarding questions.
One is entitled to provide clarity. It also helps the discourse. My Lord, like I said earlier, the government of that decision was to the effect that to the extent that the Judicial Council had made a recommendation of all four, it doesn't matter the order of merit. It doesn't matter the order of merit. The president could choose from amongst the four, whether from the bottom, in the middle, or whatever. That is it. And I remember the end phrase of my Lord the Tuguba was that mutatis mutandis, the case is dismissed. And we all laughed loudly in court, and then we walked away and thanked the bench. Now, you have given some explanation to the scenarios I've given. I want to know from you specifically, what is the opinion you have on the phrase, the president acting on the advice of the Judicial Council? The context of this phrase in the provision. What meaning do you give to this?
Thank you, Honorable Chair. Honorable Chair, for Ghana, as I said, that is the decision that has been rendered by the Justice Atuguba. I remember your case, but because it was consolidation, each of them maintained their identity. So now if you read, you will still say that it is different from yours because it was consolidation. And in the judgment, you read them independently, the conclusion. Now, this is how Ghana has construed it. We have the same provision in Sierra Leone. But the Sierra Leone one, the same provision, word for word, they are saying that the Judicial Council, which has the Attorney General, may liaise with other stakeholders and come out with names to be considered by the President. That is for Sierra Leone. But Ghana, this is the interpretation that we have given, and it is binding on me. Thank you, Honorable Chair.
Thank you. Yes, you have the floor.
My Lord, I want us to deal with statutory construction and executive discretion. You had earlier on talked about enactment providing some penalties. Someone was asking you about social media and all, and the press freedom. And you made it clear that some of the enactments on communication law electronic communication makes provision for some penalties that criminalizes it, although it's still seen in the context of free speech, but it has criminalized it. Now, this one, I'm relating it to the Minerals and Mining Act and our Immigration Act. Now, when laws provide both criminal penalties and deportation powers for the same conduct, which of them would take constitutional precedence? Can the executive choose administrative remedies over legislatively prescribed criminal sanctions? In the case of a foreigner, that we will not prosecute, but we are going to exercise administrative discretion of deportation.
Honorable Chair, I don't know the context, so I will be at large. What I will say is that where the law prescribes that if the person is convicted,
then let me limit you to help. Let me give you the specifics so that you don't have to spend a whole period. Does that work with you? Very well. So, my lord, on this issue of illegal mining, we have citizens of Ghana who are caught, arrested, and they face prosecution. Government announced that for foreigners, they will invoke their executive powers given them under the Immigration Act to deport them. What I want to know from you is that, in view of the law criminalizing the action, the conduct, can there be an administrative remedy over a legislatively prescribed criminal sanction? Can that take precedence over the criminal sanction provided for by the law merely because the person is a foreigner?
No, Honorable. But Honorable, the thing about the thing about criminal law is that the state exercises eminent power, because the state may decide, that even enter no prosecutor, don't do this. So that power, even though it may not be palatable, it may not be acceptable, once the executive has the power to control criminal proceedings, it may do it.
My lord, do you think, from what you've just said, would you want to suggest to us that there are constitutional limits on prosecutorial discretion when statutory criminal penalties are mandatory rather than executive discretionary powers being exercised? Is that a suggestion?
Honorable Chair, what I'm saying is that the power to prosecute is vested in the Attorney General. Attorney General may decide to prosecute or not to prosecute. Somebody may be a thief. The person might have been seen holding something, but the Attorney General says, I will not prosecute you. You cannot compare Attorney General to prosecute. That is what I'm saying. But I'm not saying that whenever there is a conflict, that is how it should be resolved. If there is conflict in the law, that's why I am a legal interpreter. I can resolve it. Thank you.
Yeah, so, my lord, the mainstay of my question, and I believe a lot of Ghanaians are concerned that we are caught in the act of illegal mining. Because I'm a citizen, I am facing prosecution. Because another is a foreigner, the executive directive is that we should invoke the Immigration Act that allows for the prosecution. It is that context that I am trying to tease your mind on. It is not that discretionary power of AG to prosecute or not to prosecute, but I'm juxtaposing this against the idea that, well, somebody is to be prosecuted if he's a citizen, but a foreigner, we should go for deportation without prosecution. I think that's the mainstay of my question.
Honorable Chair, thank you very much. Actually, let me be honest, I don't know the circumstances that led to the deportation. That is why I don't want to commit myself. I don't know when it happened. I'm not abreast of the facts.
Okay, I can update you. I can share with you.
All right.
I can share with you. So recently the Interior Minister announced that for foreign nationals who are caught in galamsey activities, the decision of government is to the effect that instead of prosecuting them, they will be deported. It is on that basis that I am teasing out this question of where there exists prosecutorial discretion. Would we want to, at the same time, deny ourselves of that and go for an executive discretion that denies us the opportunity to punish for that offense?
Honorable, if I understood you well, the executive discretion emanates from a law, and the law empowers the executive to do that. Am I right?
Exactly so.
Good. If it emanates from a law and
the executive, the enactment allows the executive to deport.
Thank you.
Not for the purpose of the offense. Not for the purpose that allows you to deport. The executive can choose to deport anybody without giving reason. That's what I'm referring to.
In the eyes of human rights, you cannot deport somebody without assigning reason. Even if the person is illegally present in Ghana, you must assign reason before you can deport, because there are several cases in the international court where the states have deported people and they have been held to have violated the rights of those persons. So even if the person is wrong, the person must know why that person is being deported. That is the first thing. Then the second thing that I would like to say is that the power to prosecute is with the Attorney General. So if the Interior Minister is saying that I am deporting them, Attorney General, I will not allow you, then the Attorney General may say that for me, an offense has been committed. I think that there is a case for the person to answer. I'm going to prosecute. That is what can be done. Apart from this, I don't think I can profile any opinion. Thank you.
My Lord, let me take your view on Article 66 of the Constitution. My Lord, in your considered view, what is your take on Article 66?
My personal understanding is that there is no ambiguity, and therefore no president can go for more than two terms or 4 years. To me, I don't see any ambiguity, either from literary point of view or from the purposive point of view. I don't see any ambiguity.
So this argument that if it is not consecutive, it means that there has to be an interpretation to it you think nothing triggers any interpretation?
But to me, no, it doesn't generate any interpretation because there is no ambiguity on the face of it.
Please, have you heard Professor Kwesi Prempeh, the chair of the Constitutional Review Body? Have you heard his view on Article 66 recently?
No, please.
You've not heard his view?
No, please.
Okay.
Maybe I wasn't in Ghana and I haven't read it.
Very well. Very well. Anyway, he expressed a view not different from yours. He said the 2 terms is 2 terms and it cannot be consecutive or otherwise. 2 terms is 2 terms. So I think he agrees with you. I mean, you and him have the same view. Thank you. Now, let me deal with issue of due process requirements. Where cohabitation powers. And you have Article 19. Would you hold a view that in the absence of due process, where the underlying conduct constitutes a criminal offense, one cannot sidestep this and move away to directly deport a person?
Honorable Minority Leader, please try and one up before 6:30 in view of the fact that we agreed to take another nominee.
Chairman, with respect, I am asking my questions. If at any point you want to stop me with the exercise of your powers as chairman, you can, and I will not protest. So I will ask my questions. I'm not done. But if you think you are the chair, you have the powers, let history record it, and we would comply with it. So let me finish my questions.
With all due respect, you have 6 more minutes. You have 6 more minutes.
Chairman, no problem.
At exactly 6:30, I will plead with you to...
Chairman, I am asking my questions. If you get to where you want to stop me, you can stop me, and I will not challenge you. Honorable nominee, given the absence of comprehensive legislation, courts have relied on equitable principles to address cohabitation disputes. What is the appropriate scope of judicial equity in family law cases involving cohabitation?
Honorable, cohabitation in respect of property acquisition, it is treated as people who have acquired properties, but not within the context of marriage. You can acquire property with a friend, you can acquire property with a girlfriend, you can acquire property with anybody. When it comes to dispute, the question is who provided the money that was used to acquire the property. It will be based on evidence. To say that I have befriended you, we have cohabited, and therefore you have put up a house, and I'm entitled to this, will not fly, because the law is that even enemies can jointly acquire properties, and when there is a dispute, we must determine the contribution by each one of them. If it is determined and there is no contribution, you go home peacefully. Thank you, Honorable.
Honorable nominee, for the purposes of due process and certainty, would you propose that a law be enacted to regulate Article 146 of the Constitution?
Thank you. I think if you get either a statutory instrument or CI, it will help.
Now, upon your reading of the Constitution, would you say that there is any provision that prohibits same-sex marriage?
Honorable Chair, as at now, there's no matter that I'm involved or I'm writing on. So on the face of it, I cannot say that it is either this or that, because if there is a matter or I'm writing an opinion, that's where I can. Because just to say that on the face of it, there's no sense, I think I will not act as a professional judge. I'll be acting in vacuum. Thank you.
Now let's go back to Article 144. We're talking about presidential appointment of Supreme Court justices with the advice of the Council of State in consultation with the Judicial, with the advice of Judicial Council and in consultation with Council of States. And of course, it follows with prior parliamentary approval. Would you want to precisely define what your understanding of consultation in this context means?
We have two words here, advice and consultation. Advice has been held to be stronger than the word consultation. Advice, they must offer, even though it is not binding on you, you must. Consultation, you can just meet them and say, I have A, B, C, D. These are the CVs. What is your opinion? And if they say yes, you may go ahead.
And if they say no?
The general law is that once it is either an advice or consultation, if they say no, they must justify why it is no. But if they say no, that one you cannot proceed because they are advising you against it, or you need my consent, and I'm saying that this one I will not give you consent for the appointment. Thank you.
So your view is that where it is a no, the appointor cannot proceed. That is your view?
Yes, and if reasons are assigned why you do not, why you think that I should not appoint that person. Example, if it is a personal hatred, you went to court and you had a matter before the court and the judge ruled against you. You cannot use this one as basis. Thank you.
Honourable Minority Leader, with all due respect, may you please ask your last question so that we can make progress.
Honorable nominee, Chairman, I disagree with you, but I will yield to your authority, please. Honorable nominee, the Constitution and Article 146 has provided for what is known as stated misbehavior. It permits a removal of a justice of the Supreme Court without defining the term. In your opinion, what would you consider to be stated misbehavior that would guide the exercise of such powers by the authority?
Thank you. Thank you, Chair. Chair, even though you say that the Constitution is sui generis, and therefore it is not advisable to borrow elsewhere, where you can interpret it within the context of the local materials. But in some cases, you may need inspiration from other countries. There are several jurisdictions that the word misstated misconduct have been established. So you may look at some of them and you allow yourself to be persuaded within the context of this constitutional provision. Thank you.
Yes, I agree with that, but do you have your own view on this stated misbehavior? Because you are a member of the bench, would you want to express a view, I mean, outside of the other definitions in other jurisdictions? Would you look at it from the ethical point of view or a criminal conduct?
Thank you, Honorable. If we look at the law, it talks about misconduct. And misconduct, it doesn't say criminal misconduct. So it could be either criminal or civil, depending on the behavior of that person. Example, if I'm a judge, then, Honorable, you appear before me in court. I said, leave my court, don't come to my court anymore. Then I ask my usher to carry you away from my court. It is contrary to my ethics, and it is contrary to the code of conduct. And therefore, that one will amount to misbehavior. So you can get several examples depending on the facts in issue. Thank you.
Thank you very much, Honorable Minority Leader. That brings us to the end of vetting of the Honorable nominee. May I proceed to acknowledge the guest of the nominee. First on my list is Mrs. Agnes Akosua Edrujemfi Aje. I believe that's the spouse of the nominee. Then we have Reverend Father Andrews Campbell. We have Bafo Aje Fosu Chuchikua II, Asantehini Anantahini. Then we have Nana Kwesi Oko II, Manso Tetremhini. Then we have Obrimpom Hima Dechi, Paramount Chief of Upper Discourse and Overlord of Discourse. We have Nana Asamoah Tia II, Mpatum Hini. We have Mr. Joseph William Baini, Professor Rose Emma Mama Entua Mensa. We have Samuel Ado Otu Esquire. We have Justice Eric J. Bafo, Justice of the Court of Appeal. We have Justice Efia Sawa Asariboche, Justice of the Court of Appeal. We have Justice Charles Edward Ekobedi, Justice of the Court of Appeal. We have Justice Christopher Acha, Justice of the Court of Appeal. We have Justice Kizita Kowa Kwashi, Justice of the High Court. We have Majib Rahman Ahmed Esquire. Mujib, very well. We have Mrs. Felicia Dapa Ajiman, Chief Director, Office of the Head of the Local Government Service. On behalf, very well. We have Wami Yafi Ajay Esquire. Then we have Ms. Veronica Yabua, Mrs. Bridget Boachi Ampedu Esquire, Bafo Asari Krantin Esquire, and the Chief Justice and other justices of the Supreme Court that I have earlier acknowledged are also present with us till now. May I use the opportunity to welcome you and thank you for coming. Honorable nominee, we thank you very much for attending upon the committee and answering questions. You are discharged, but you hear from the committee.
Thank you very much.
Thank you very much. Our next nominee should take the chair.